Welcome to this week's video blog on the law. This week I'll explain why, when you've been fired from your job without good reason, you might make a complaint with the BC Employment Standards Board, or why you might be better off pursuing your claim outside of that process. Let's start with some basic principles of employment law. First, an employer may fire an employee for almost any reason, provided they give the employee adequate notice of the termination, and either allow them to work through that notice period or provide them with the pay in lieu of working the notice period. In other words, an employer does not have to keep a person employed if they're unhappy with them, but they do have to pay to get rid of them. The exception to this general rule is that an employer may not terminate somebody for a reason that's discriminatory. Discriminatory termination is a human rights breach under the BC Human Rights Code. A decision to terminate someone is discriminatory whether the employer intends it or not, if the decision is based on race, color, ancestry, religion, marital or family status, physical or mental disability, sex, sexual orientation, or gender identity. We'll cover human rights breaches in another video blog, but for now, let's move on. The second fundamental employment law point is that an employer may fire an employee and avoid giving any notice or paying any pay in lieu of if the employee's conduct is so egregious that the employment relationship cannot continue. This is called termination for cause. We will cover what justifies for cause termination in other blogs. For now, if an employer does not terminate an employee for a reason that amounts to cause, they are responsible to pay the employee the minimum severance required under the BC Employment Standards Act. The BC Employment Standards Act is written law or statute enacted by the BC government and is enforced by a government agency called the Employment Standards Branch. The minimum severance under the Employment Standards Act amounts to 1 week of wages after 3 months of service, 2 weeks of wages after a year of service, and after 3 years of service, 3 weeks of wages plus 1 additional week for every year of service up to a maximum of 8 weeks. Note that I said the Employment Standards Act's jurisdiction to award severance maxes out at 8 weeks. Many employees who were fired jump to making claims under the employment standards process thinking it's their only recourse. That's incorrect. Outside of the employment standards process, the employee can make a demand for severance based on common law. Common law does not come from a piece of legislation like the Employment Standards Act, but comes from the decisions of judges and courtrooms that have developed over many, many years. The common law is generally much more generous than the law provides under the Employment Standards Act. As a general rule of thumb, an employee may receive about a month of severance for every year of service with an employer, which is 3 to 4 times that provided under the Employment Standards Act. The amount of severance paid under common law will vary, however, from case to case, and will depend on a variety of factors such as the age of the employee, their experience and qualifications, their seniority, and generally how difficult it will be for the employee to find a similar job. Many employees can make a demand for common law severance and negotiate that amount with their employer without the help of a lawyer. If the negotiation is not successful, the employee can file a claim in BC Small Claims Court and seek up to $25,000 of severance in that court. Larger claims must be heard in BC Supreme Court. In more serious cases, where the length of employment has been longer, such as 4 or 5 years or more, the employee might seek the help of a lawyer to pursue their claim. Larger severance claims often result in the employer alleging they had cause to fire an employee, even if they didn't, just so they can avoid having to pay the money. An employer will often put in issue the employee's competence and honesty, and having an objective advocate to combat these allegations is important and will remove much of the stress from the employee. I hope you've learned something about the law from listening to this blog. Please feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel below. Thank you very much.